Now we're official, recordings in progress. This is chapter 2, or maybe chapter 52 of the LOCI hearing. We met last on April the 2nd and heard presentations from the applicant and the appellants. And we went into session to start considering, as the Board of Appeals, what our decision was going to be, and we decided we needed a little more time to consider the evidence. And so this is the result of that time being allocated to us. We need to determine that we have a quorum here for the Board of Appeals, and I see between Tom and Dylan on Zoom
and John
on Zoom, that we have a quorum here. We have the full board here. All of us are here. So that's great. So we can proceed. I will remind everybody that we are now considering the evidence that was presented on April 2nd, and that no one else is allowed to speak during this discussion. If the gods are willing, we will come up with a decision tonight. Patrick Lyons, you're taking notes and are going to write the decision letter. Is that correct?
Correct.
Great. All right. So without further ado, anybody on the Board of Appeals have questions that we need to discuss amongst ourselves to get clarity on anything? Susan, you wanted more time last time. We've got more time. Are you?
I have questions.
Okay.
I have specific questions with the different papers that came in last meeting, the post findings and what people wanted. And I have a couple really, lawyer Patrick. I have questions about, basic questions about, the one big question. So I was rereading the sections of the ordinances that we have to be making decisions by. And regarding chapter 125-2, the big question is, legally from your perspective, did the planning board adequately, quote, anticipate and respond to the impacts of development in all areas? Are there any ways that you see that the board did not adequately anticipate impacts of the development in the areas, even though there's no houses being built on those 3 lots in the division of the property? In terms of, the anticipation is that there would be people building buildings there at some point because of the discussion about roads, how you would access those lots, and also the pits in terms of, is there adequate qualities of the land for septic and so on. So would there be any legal objections to what the planning board came up with that specific language in chapter 125.2 of the ordinances?
Sure. So, I just first, before I answer your question, I just want to clarify, my goal and my job is I don't want to put my finger on the scale one way or the other. I want you guys to be able to come to your own conclusions. I'm just trying to help you get there and make sure you're following the proper rules.
Right.
So, the question, so I don't want to answer that question, because I think that's something that you guys need to come to your own conclusion on. And I think what you need to do in that instance is, look at the applicable language in the ordinances, as far as the planning board's discretion. I think what you're asking is, did the planning board have the ability to waive certain requirements, in the subdivision ordinance, because the proposal did not provide any actual development proposals as far as structures. It was just a division of land. And so as I understand the issue is, did the planning board have the discretion not to require certain provisions in sections of the subdivision or ordinance be applied because they weren't applicable? And the ordinance does provide some language as to when the planning board can waive certain requirements. So I think you would look to the language in the ordinance to see if you believe that they were within their discretion to not apply these certain provisions, such as requiring fire hydrants or noting certain features on the plans because there was no proposal to develop any homes at this time.
So a follow-up question in that, because in one of them, I would have to look that up, I think it was the findings for the Dexters that their lawyer wrote up, is that because the planning board said these certain aspects don't apply because there is no anticipated building going at that time, that doesn't mean that when someone buys one of the lots and wants to build, that doesn't mean that those issues that were said does not apply. They now will apply, right?
Yes, I believe that was the intent of the planning board, as I understood it, was that we'll approve it just for the land subdivision, but if someone comes forward and wants to develop the lot, they have to satisfy any remaining provisions of the ordinance that weren't addressed
Okay.
at the meeting last in December.
Right, the way I read it was that because it's just a division of land,
I understand. Yeah.
then if somebody comes back with something else, you get a second bite at the apple.
And that's really, I want clarification on that, because it seems some of the objections by the ones appealing had to do with, well, it's making it seem as it's all fine and we don't get a second shot at this. But that's what I wanted to just clarify legally, that would be the case.
Yeah, and to your question as well, I'd point out that in the town's ordinances under section 45, 124 through 127, it addresses the authority of the planning board to waive certain requirements, submission requirements, performance standards, things of that nature.
But not that waiving, it cannot be interpreted by someone else to say they're completely waived.
Yeah,
Just
again.
It's only for that specific action.
Yeah, so I just want absolute clarification on this of what the planning board decision laid down.
And reminder to everybody that what we're determining here is whether the planning board stayed within the lines of the ordinance, and whether the facts that they used were accurate. So it's essentially, we're essentially trying to decide whether the planning board followed their ordinances in issuing the decision.
And on that note, Patrick, at the specific standard that you're applying is in section 15 of the ordinances, and you're acting in your appellate capacity. So when acting in your appellate capacity, the board may reverse the decision of the planning board only upon a finding that the decision was contrary to the specific provisions of the ordinance or contrary to the facts presented to the planning board. And then such appellate review is limited to the record of the proceeding before the planning board, and the board shall not receive or consider any evidence that was not presented to the planning board. And so on. But that's the lens you guys are looking at this through.
Then another question, unless someone else has one right now. In terms of the right of way into the property, lot 3, which was then combined with the lot 4, which is now all one lot 3. Questions about the right of way, which were very thoroughly argued, on both sides and everything, reviewing all the information. Is that something that could be revisited if one of the parcels was sold and someone wanted to buy? Would that be revisited also in terms of right of way? Particularly where the right of way seems to be, is it really there? Is it not really there?
So I would say no, that issue, and if you look at the case law that was provided by the applicant in their filings on this issue, and if you also recall that the planning board's attorney advised the planning board on the right title interest issue, and basically the law says you have to show that you have a cognizable expectation, I believe, or there's link. It's not you don't have to prove to the letter of the law that you can in fact use this right away. It's that you have to show us that you have some kind of right title interest that says that you have access, and whether or not that is correct is not for the planning board to decide, because that's a legal issue. It's a threat. This whole right title interest issue is a threshold matter in the sense that it's designed to keep out applications that should have no business being before a board because the people don't even have the right to do what they're going to do. But beyond that, it's a threshold requirement, and once an applicant shows that, if there's any dispute between other individuals that may be impacted by this issue of an easement or access, things of that nature, that's a private dispute between the property owners.
Okay,
So to answer your question, I don't believe that the RTI issue would come back up for the planning board to. They may just ultimately in a future planning board may want to bring it back up for some reason, or the ordinance might change too. That's always a possibility that the standards could be different. So it may, but ultimately this issue is not, it is typically has to be resolved if there's any dispute about who has exactly what right between the private parties.
okay, and that means like in a court of law or it's some legal agreement between people. Okay,
Yeah, there could be a quiet title action in court, or there's all kinds of ways to go about that. But again, the planning board, you're not a court of law, or they're not a court of law. You're not here to determine who has what property rights. You're just their job is to apply the ordinance standards to the application. And the RTI issue, again, is just supposed to be a threshold.
and
kind of
would that
question.
also then apply what you're saying that will be a quote unquote private issue having to do with the fact that the right of way from the old paper trim lane road and whose land, how that would be divided right now. It looks like it's all of that trim lane road now is part of the Losey's property. If I understand correctly, that the Seekman complaint is that they've just lost part of their half of that original paper road. Would that also a dispute about where an old right of way was, that would also be a private issue that would have to be handled?
Yes.
Not with the board, certainly not with us, but that's private and outside of the realm of this. And that
Correct.
would.
Yeah, that's my interpretation of the situation.
Yeah, boundary disputes are not our
Okay.
purview.
Now, I want to clarify this because I think that hit on the main points of the appeals having to do with the objections to the division, the amount of lots and the right of ways, to be sure that, and this was really my question before about whether the planning board had, fulfilled what I had quoted there from section 125. Or part 2, I think. And this answers those questions for me, that all these problems will likely come back and have to be dealt with either privately or again by the planning board, in terms of what buildings will be built there and so on. And one other point I want to say is that it would be perfectly legal if if somehow the right-of-way issues became a bigger tangle than they have been, that a driveway, a road could be put through the Losey's land connecting the different lots, and that would potentially be a legal thing to do if there was, legitimate legal decisions not made by us about whether there are the right of ways to lot 2 and 3, which were also part of the objections. Is that right? That like a road could be built if need be?
I can't say with any certainty. Again, yet the ordinances, there's requirements for roads of where they can go and such. But let's just say, for the sake of argument, that a road can be placed somewhere else on the property. That would potentially be a solution to any form of private dispute between landowners. The issue then would be they'd have, if that new road location was in any way deviated from any previous approvals, such as a subdivision approval, the town and the would not be involved in any way until some kind of resolution happened, and then a party may come back to the town to seek new opinions.
All right, any other questions on the facts at this point?
Yes, I have a follow-up, sort of on the same issue. If we could reference the proposed findings of fact and conclusions submitted by Dexter, Bill Kelly, on page 7 of that 15-page document, item 10. This references a statement from a legal opinion from Natalie L. Burns that seems to say to me that the planning board should ask the applicant to provide a legal opinion. And we are certainly talking to you, Patrick Lyons, as our appeals board. But of course, you're advising us on the appeal. My question is, has the planning board satisfied this requirement to provide for the applicant to provide a legal opinion?
Tom, can you?
Give me
So
the
I'm
citation
looking-
again, Tom.
Yeah, because I got to page 7, I didn't see a number 10. I'm on the April 11th submission from Bill Kelly on behalf of Dexter.
Oh,
Yeah.
I'm sorry. It says page 7 down here, but it's actually of the document. It's page 4. I'm sorry, because this included that in the cover letter also. You say my audio's not good?
No, you're
Oh,
okay.
yeah, I can hear it. Okay, so I see. I found it, Tom.
Okay, thank you.
Yeah, and then it says the Losey's were on notice of the legal opinion from Natalie Burns in the record, which stated if neighbors submitted conflicting deeds and surveys, then the planning board should ask the applicant to review those and provide a legal opinion, since the applicant has the burden of proof on all issues. Okay, so your question is, do I think they should have done that? Is that correct, Tom?
Or have they
Yes.
done?
Yes.
So again, I don't want to tell you guys, I'm careful not to provide any, I don't want to tip the scales one way or the other.
Mhm.
I think what I would do is point you to the planning board's decision on they're addressed, this issue. And beyond that, I will note, all right, I will note that subsequently the planning board's attorney advised the planning board, I believe this is correct. And again, so that's why I want to be careful. But I recall that later in the proceedings, the planning board's attorney, Kristen Collins, who provided comments at the board's last meeting, and I believe, provided the advice that RTI was satisfied, the right title interest issue was satisfied. Deeds, yes. So that's what. So, there may have been one attorney advised the planning board one thing, but then I believe subsequently, the boards had received the advice that RTI had been satisfied as far as the burden at this stage. Again, it being a threshold issue.
Okay.
Does that help, Tom?
That
And
helps.
yeah,
Yes.
just to be, so really, and that may have been in part to address that. Um, advice saying, hey, you should get an opinion, and then the planning board's own counsel advised it that it had been satisfied.
Okay, that's slightly different than asking the applicant to
Yeah,
provide a legal opinion. Um, but
Yes,
but in
and
sub,
yeah, at the end of the day, it appears that they got to the request, the advice is you need a legal opinion, and rather than from the applicants, they got it from their own legal counsel.
okay, all right, I understand.
All right. Anybody else? Patrick, what is our best way to proceed at this point? Should we just go through each appeal and discuss each point and sort of yay or nay on it?
Well, so you can. I just want to note a few things for you. One, regardless of which way you decide, if this matter is then further appealed to Maine Superior Court, um, your decision is not the decision the court will actually look at. It
Right,
is the planning board's decision. So I guess in the sense the pressure's off a little bit about how detailed you guys want to get into your analysis. What you do have, and again, one of the reasons I advised you to request proposed findings and conclusions from the parties is that you can adopt
right.
either any of them if you're so persuaded by their in the way they've been framed. So I think what might be helpful, and again, it's up to you. You can walk through one of them or all of them and say, "Hey, here's what we think on each issue." Another way to you could proceed is to just generally discuss, do we believe that the appellants satisfied their burden to show us that the planning board, again, the standard of review, um, that the findings were clearly contrary to specific provisions of the ordinance or the facts presented to the planning board. So you might be good to have a kind of more broader universal discussion, and then that might help you lead to, okay, if it seems like everyone's going one way or the other, picking up the proposed findings that would support that decision and maybe going through them. And if you feel as if provide you, you accept them and you agree with them, you could just vote in total to adopt those findings and conclusions. And then that would be your findings. And then again, if it is appealed, the Superior Court won't even care about your decision. You just need to have it done, and then they'll go back to the planning board's decision to review one way or the other.
All right, so, I mean, the basic threshold to all of this is this right title and interest issue, it seems to me. And are the members of the Board of Appeals satisfied that the Losi's have demonstrated that they have right title and interest to these parcels? To be able to do what they've asked to do? I see Peter shaking his head, yes. Tom?
I'm satisfied on that issue, and that certainly seems to be the core about access and right of way. I sympathize with the abutters, the appellants, that there are so many conflicting documents and descriptions of right of ways, but again, that's not our issue to resolve.
Right,
My other piece was that I was just trying to think about the actual technical steps of the process. And I can't find anything to put my finger on that said that the planning board acted incorrectly.
Okay. John, what do you think?
I'm still, like I said at the first meeting, after going over a lot of these documents, I don't think I think I agree with the planning board. This is more of, deeds, right-of-ways, things that the planning board just went on what they had, and a lot of it was what I feel was A-okay. And there was never any other counter surveys or other legal things like that coming in, and I'm just basing what I have in front of me. And like I said, the last meeting, I feel the planning board made the right decision and followed the ordinance for specifically granting that subdivision based on the information that I had in front of me. And then I think somebody said, if something else goes on when it comes to developing or whatever it is, that's a whole nother set of things that that the planning board will have to look at. But
Right.
we're here just to look at this piece. And I vote in support of the planning board.
Susan?
I do support the planning board.
I do too. Do we need to get into the details of each specific? I think the planning board followed the rules of the ordinance. I mean, I'm hearing that from, 5 members of the appeals board. Sorry, you guys that are, alternates or, you're just baggage today. Well-informed baggage. I feel like they've demonstrated, right title and interest, and that the planning board followed the ordinance correctly. And as John eloquently put it, the information that was presented to them supports the decisions that they made. Do we need to go any further than that, Patrick?
Well, I would to go one step further, but it would not. It wouldn't be a heavy lift because again, the applicant provided you proposed findings, and I know the board has all had time to review them, and unless anyone from the board has any specific, portions of that proposed findings that they disagree with, I would advise you, the planning board, to you know adopt, if you're going to vote to deny the appeals, to do so, and by adopting the proposed findings and conclusions. You can look at page 13 of that document, and that and it will really, at the end of page 12 it says board decision, and then on beginning of page 13 there's there's 3 paragraphs, one addressing the Seekman appeal, one addressing the Dexter appeal, and then the third just kind of saying this is the final decision. If those 3 look good to you, I would advise you to vote to adopt these findings and conclusions. And you could, if you have a printed copy in front of you, you could sign it there tonight, date it.
Yes,
And
my name is not on this, so I cannot do that.
But you can take a blue pen aggressively to it and cross out or add your name however you would like.
Cross out John Burrington and add
No.
Susan West.
The also if you would like, I could prepare it. I could do a little massaging to the document. I do have a Word version that was provided by the applicant's counsel, and I could massage it just to clean it up a little bit in that sense. But in all honesty, if you just want to if you have a printed copy of it tonight, you could just use a blue pen to fill in any dates, add the name of any board members that weren't included. I would go to the first page and cross out applicants proposed at the very top of it. And then it would just be your findings of fact and decision by the Board of Appeals. And then vote, sign, and date it. And that would conclude it. And again, this decision is not what the court will review, but this decision will, if they were for whatever reason to challenge the validity of it, I believe you would have sufficient findings and conclusions. Whether or not you get it right is separate from that, but this is sufficient from a procedural requirements.
Did everybody get a chance to read this with the
Sure.
findings that were presented?
Yeah.
I mean, I've read it and supported the findings. I agree with them. Peter's nodding his head yes. Tom?
Yes, I have read them and I agree with them also. I would feel better if Patrick Lyons cleaned that document up instead of us just marking it up with a pen. And then we would all be able to sign it as he in the final version.
That sounds good to me too, yeah. Carrie?
So I'm happy to do that.
Hang on.
Oh, I'm just offering, it can be emailed to me and I can print it out immediately.
Okay, so Carrie's saying, Patrick, once you've put something together, Carrie can print it out and send it to us or get us to come in and sign it and
Or
whatever.
even tonight, like if he did it right now.
Even, yeah.
I'm
So we're-
I'm doing it right now. So let me just, so we've got Patrick O'Bannon, Tom Tudor, John Kerr, Peter Wilcox.
Peter
And
Wilcox
then-
needs another L in Wilcox.
Yeah, 2 L's in Wilcox.
Okay, and then Dylan Purington is an alternate, so you wouldn't be voting.
Right, so it's Susan West.
Susan Webb.
West, W-E-S-T.
Okay, all right. So I've got Patrick O'Bannon chair, Tom Tudor vice chair, John Kerr, Peter Wilcox with 2 L's, and Susan West. Okay, I'm going to send this in about 2 minutes to the clerk. And- Secretary, sorry, but
Or God knows where it would go.
That's Dave Dyer's other email. Yeah.
but you guys can go. I would advise. I think what the board should do is the board decision that starts on. I'm going to now have it start on page 13. I would advise you to read those 3 paragraphs, and then that would be your vote, and see who
Okay.
gets to approve.
What page does that start on again, Patrick?
Starts on the last page of the document.
13. Lucky
13.
page 13.
Okay.
All right. Well, I'm having some formatting issues. I think it just has to do with, but I have all the names. You'll just see there is not a spot to sign for Peter, a line, so that Peter can just write it. Well, Peter's not even there, so when
Okay.
Peter comes in,
Peter's here.
I'm looking at Pete Anderson. Sorry. Hey, Peter, there you are. You do exist. It's just going to get a little cramped on the page.
But this double spacing thing,
Patrick O'Bannon, do you
Yes, sir.
feel that you should read these 2 items just
I
for
just did.
public record? I know, but should you read them orally just for the
I can
sake
do
of the
that.
public?
Oh,
Sure.
Yes, and to Tom's point, I would advise that those 3 paragraphs be read, and then the board vote on whether or not to approve them
Okay.
in the
Yeah.
entire decision.
Okay, number 1, based upon the above findings and the consideration of all evidence submitted to the planning board and oral and written arguments submitted to this Board of Appeals, the Board of Appeals finds that the appellant, Kara Master Siekman, did not meet her burden of proof as to her arguments on appeal, that the planning board's December 15th, 2024 adopted findings of fact and decision were contrary to the specific provisions of the ordinance or contrary to the facts presented to the planning board. The planning board's approval of the applicant's 3-parcel subdivision is sustained and affirmed. All in favor of adopting that, please signify by saying yes.
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 We
Yes.
have the
Yes,
roll call because it's on. Zoom.
right. Do I need to call everybody individually, Carrie?
Yes, but I may have a correction to that date. It was December 16th.
Oh, December 16th, 2024. All right.
Thank you. Thank you.
And yes, you need to do roll
All
call
right.
because
Peter,
Yes.
Tom,
Yes.
John,
Yes.
Susan,
Yes.
Patrick, yes. Paragraph 2, based upon the findings and the consideration for all evidence submitted to the planning board and oral and written arguments submitted to this board, appellants Thomas and Glenda Dexter did not meet their burden of proof as to their arguments on appeal that the planning board's December 16th, 2024 adopted findings of fact and decision were contrary to the specific provisions of the ordinance or contrary to the facts presented to the planning board. The planning board's approval of the applicant's 3-parcel subdivision is sustained and affirmed. Peter,
Yes.
Tom,
Yes.
John,
Yes.
Susan,
Yes.
Patrick, yes. The last one is, this is a final decision of the Board of Appeals dated April 22nd, 2025. Peter,
Yes.
Tom,
Yes.
John,
Yes.
Susan,
Yes.
Patrick, yes. All right. Yes. So Attorney Patrick, you're sending this off to Carrie and then we can sign it?
Yes.
Yes.
And I can come into the town office on Thursday and sign it.
Okay. How about you, John?
Oh, you're muted.
You're muted.
I hope to be on the island. I've got a family crisis going on with 2 aging parents. One's passing away at the moment as we speak. So, they might be on a road trip. I mean, you're 97, you know, I mean, you made a good life. So, it's a little up in the air. I mean, is there any way it could be sent to me DocuSign, or I could sign something to you just to be on the safe side? But if not, I should be in. But that's what's going on.
If we need, if you have to go away, both Dylan and Ben have been here and we can get them on record for voting. What, I mean, can we just have them vote now on those 3 issues and then substitute one of them?
I'm
I
fine
mean, I think if John's signature, you have 4 of the 5 when John's able to
That's
sign
true,
it.
we have a quorum.
Yeah, it's not gonna tip it one way or the other. So I would just, or you
Okay.
can always, they can always try to send it, the town can always try to send a DocuSign.
Okay, John, well, hopefully you'll be able to come in. Wish you the best.
Thank you, Patrick. I hope so too.
All right, can I get a motion to adjourn?
I so moved.
Second.
All in favor? Yes, yes, yeah. Thank you all for your patience through this process.